Hey everybody, it's Valerie Zammitti from Zometi Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. In the next few minutes, we'd like to answer the question of when a living trust is the right plan for me. Before we get there, however, if you have any questions about this topic or anything estate planning or probate related, please feel free to reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Now, this question is sort of the middle of our three-part video process about whether a will, a living trust, or irrevocable trust is the right fit for me. We want to make sure everyone has a base understanding of these different types of plans and when it's appropriate for them to be seeking that type of assistance. First off, we do sort of look at the net worth of your assets as an indicator of what level of plan you may need. It's not the only indicator, but it is a part of that puzzle. So in my eyes, and in having done this planning for some time now, I would almost automatically put someone in a living trust category if their net worth exceeds $500,000. And that net worth includes, of course, the home equity that you have where you live, liquid assets, retirement accounts, and life insurance policies other than term. It also is useful to utilize a living trust if you own property out of state. This way, your family can avoid probate process not only where you live, but in that other state as well. And in general, living trust is typically a much more robust plan for those who are seeking something with a bit more flexibility and seamless protection for you and your family. Now, the downsides to a living trust really are twofold. One, it does cost a little bit more to set up typically than a will, and you have more homework to do. Those are usually hopefully guided by the professional you're working with, but there's a little bit more legwork once you have it set up to ensure that it's properly funded. On the positive note, trusts are certainly much more flexible. They are valid in all 50 states, so if you do happen to move, that piece of your estate planning doesn't necessarily have to change. It does avoid the probate process, and so the family doesn't have to go through the courts or deal with a judge in trying to settle your affairs after you're gone. It is a private document, never becomes public record. And it is very easy for your successors to step into your footsteps at both incapacity and passing. All in all, a living trust is definitely a very flexible, more robust plan for many folks and has been utilized more and more across the country and become a staple in estate planning for many folks. The misinformation that you need to be multimillionaire to utilize a trust is not true anymore, and so you should know that. It is certainly a potential plan for you. Now, as a reminder, if you have any questions about this topic or anything estate planning or probate related, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Thank you so much for listening today, and if you found this useful or think someone else may, please share, like, and subscribe where appropriate so nobody misses out. Again, I'm Valerie Zammitti of Zometi Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Take care.